The United States Constitution, ratified in 1787, has 4,543 words, if one includes the signatures. This new document has served as a model for other constitutions on a global scale. The Constitution would replace the first efforts of a national organizational document, the Articles of Confederation, which was adopted in 1781. The Articles were written to establish an independent confederation of states and to define the sovereignty, rights, and powers of that confederation. Weaknesses of the Articles of Confederation document were readily identified because trade and commerce were stilted by individual states' trade, and the fact that each state issued its own monies. One might say there were 13 independent countries created by this document. This caused economic hardship because of the high taxes and debt problems created by the war. The outcome helped to highlight the weaknesses of the Articles, and there was a call for a stronger, centralized government. Though the parties met to revise the Articles, they soon realized that starting over was the best approach. Let's start with a good definition of the results of their efforts. First, it is about principles. It is a way to establish the procedures and structures by which the government will go about fulfilling these principles. Like many operational documents, it starts with the mission. The mission can be described as long-term goals for our government. This is demonstrated by the Preamble to the Constitution. Here, the framers' intentions and purposes are noted. The Preamble reads, "We, the people of the United States, in order to form a more perfect union, establish justice, ensure domestic tranquility, provide for the common defense, promote the general welfare, and secure the blessings of liberty to ourselves and our posterity, do ordain and establish this Constitution for the United States of America." Let's break that down. "We, the people," denotes the who of the document and plants the idea of a representative body. To form a more perfect union contains the lofty objective of binding the country together as one. Next is to establish justice, which foretells of the provisions of laws and the penalties of breaking those laws in a fair and just manner. Ensure domestic tranquility proposes a peaceful existence to the citizenry. Providing for the common defense suggests a military presence to protect the citizens. Looking out for the general well-being of all of us is evident in the next phrase. And finally, securing the blessings of liberty means we as a nation should protect freedoms and liberties for ourselves as well as our countrymen. The structure of the government is described as three separate bodies. That is, our legislative or congressional branch, with responsibilities to include making laws, can confirm or reject presidential nominations, and has the ability to declare wars. Article 1 of the Constitution spells out and discusses this branch. The executive branch includes the President, Vice President, and Cabinet. The President is our head of state, acts to carry out laws, and nominates Supreme Court justices. These explanations are spelled out in Article 2 of the Constitution. The judicial branch, described in Article 3 of the Constitution, interprets the laws, applies them to individual cases, and determines the constitutionality of other courts' decisions. The beauty of this arrangement is the ability of each branch to have oversight over the other branches, to provide checks and balance in our government system. To add historical context to our conversation, we know that our country was colonized in varying stages and mostly by Europeans. These were a diverse group of settlers economically, as there were those who were wealthy, as well as those seeking opportunities for a better life. Unfortunately, as we well know, some came indentured to work in services of others for their eventual freedom, and even more unfortunately, there were slaves. The colonists were not allowed a say in their freedom and developed grievances against Great Britain because they felt they should be governed themselves and be able to protect their liberties. Much ado is made about taxation without representation, but the truth is that grievance was only one of 27. These were problems they listed as complaints against the decisions and actions of the British and King George III. As increasingly the British demanded monies from the colonists, difficult relations evolved into an incited existence for the settlers. A list of desired rights and grievances, as well as a plan to create a parliament specific to our lands, was developed and sent to the king in 1774. In 1775, shots were fired at Lexington and Concord. The next month, the Second Continental Congress convened and empowered itself to be independent and to exercise force against Britain in support of their stance. Less than a year later, in 1776, the Declaration of Independence was drafted to establish three principles. All men are equal and have natural rights. Only those who consent to govern should be governed. The people have the right to abolish any government which does not serve them and create a new government. In 1787, a delegation formed a convention to discuss the defects of the Articles of Confederation. This delegation was made up of wealthy men, educated, mostly Christian, and white. This created a perspective which many people call into question even today. But at this convention, they agreed that sovereignty or rule should be shared between a central government and a regional government. However, the national government should ultimately reign supreme. They separated powers into three branches of government to distribute control, and mechanisms were established for the various branches to monitor and limit powers so as to protect the natural rights of citizens. At this convention, as you might imagine, there were also disagreements. Our forefathers were not only elite, but they were very opinionated. Alexander Hamilton wanted a top-down government and believed the elite should have more power and the federal government should be strong. Additionally, he supported the Constitution as it was written because it reflected the strength of a federal system. It was said he advocated for the East Coast merchants. Further, he wanted to establish a central bank. Hamilton and his like-minded partners were called Federalists, indicating a desire for a strong national government. Thomas Jefferson, on the other hand, wanted a bottom-up approach to government and believed the central government should be small. He supported landowners and small farmers. The federal government would have specific and delegated powers, and the rest would be the function of the states and the people. Said differently, an expanded national power was not in their cards. Jefferson and his cronies were labeled anti-federalist. Jefferson and the anti-federalists called for a Bill of Rights to support specific liberties of the people. We can note that Representative James Madison, though originally against the Bill of Rights, understood the challenges of ratification and proposed the amendments for political expediency. Some call this process and his contributions Madison's middle ground because Madison could see an effective mix between the ideologies of both Jefferson and Hamilton. Another major compromise to the constitutional ratification process is known as the Great Compromise or the Connecticut Compromise. This was a coming together of terms between large and small states that eventually organized the structure of the legislative bodies and how each state would be represented. The outcome was a bicameral or two legislative bodies where one, the House, was based on state population, and the upper house or Senate would be equally represented. Thus, they developed both a proportional representation, that of the House, and an equal representation, that of the Senate. Let's take a few minutes and discuss some of the early and integral U.S. Supreme Court decisions. Marbury v. Madison, 1803, establishes the principle of judicial review and recognizes the Supreme Court as having the power to review legislative and executive acts specific to their constitutionality. Gibbons v. Ogden in 1824 was a Supreme Court decision that said states could not restrict trade and that Congress has the powers to make laws considered necessary and proper to execute those powers. Dred Scott v. Sanford in 1857. This was a most egregious decision where it was stated that the Constitution does not recognize slaves as U.S. citizens, but constitutionally protects property of their masters. This decision was eventually overturned by the 13th Amendment, which abolished slavery altogether. In Plessy v. Ferguson of 1896, laws which were racially based dictated that the doctrine of separate but equal status for African Americans should be maintained. In this case, the court ruled that these laws did not violate the Constitution as long as the accommodations were equal. Accommodations were separate, but rarely equal. To review, we have a representative democracy that protects individual liberties, divides governmental powers between federal and state entities, provides for a system of checks and balances, and that created the three branches of government. The Constitution is organized in three parts. First is the Preamble, or the purpose of the document and our government. Next came the Articles. There are 7 of them, and it explains how the government is structured and how the Constitution can be changed. And third is the amendments or changes to the Constitution, of which the first 10 are called the Bill of Rights.